I got a message on my screen. Meeting is now streaming live on YouTube.
That strainer,
Good.
which means if he dropped the soap or anything, we're gonna have a fucking clogged drain.
Why is he doing that?
I don't know.
For those, if you can mute yourselves, whoever is on.
Crap like that, because they don't
Yeah,
even-
can you please, whoever, please mute yourselves? So, Mr. Ferson, are we okay to proceed?
Yes.
Okay. Thank you. My apologies for a few minute delay. I am Salvatore Giorlandino. I am the Chief Presiding Officer of Mass DEP's Office of Appeals and Dispute Resolution. With me this morning are my colleagues, Presiding Officer Jane Rothschild and Presiding Officer Patrick Grew, as well as OADR Assistant Case Administrator Joseph Ferson, who is performing the laboring oar to make sure that this hearing or oral argument is live streamed on Mass DEP YouTube channel. Thank you, Mr. Ferson, for your efforts. What's scheduled today, as the parties know, is the oral argument, closing oral arguments of the parties' respective legal counsel in the administrative appeal known as in the matter of Algonquin Gas Transmission, Inc., OADR docket numbers 2017-11 and 2017-12. This is an appeal of a draft Chapter 91 license that certain Weymouth residents have filed, challenging Mass DEP's granting of a draft Chapter 91 license authorizing the compressor station at the Fore River on Phil Tidelands in Weymouth, authorizing it as an ancillary facility to the Hubline gas pipeline that is in that area. Before I go any further, I think it's important for counsel for the respective parties to identify themselves for the record. And so we'll start with the petitioner's counsel. Mr. Hayden.
Good afternoon. Good morning, Mr. Chief Presiding Officer, and also good morning to Presiding Officer Rothschild, Michael Hayden on behalf of the petitioners.
We'll go with Algonquin's counsel.
Good morning, Mr. Giorlandino. Can you hear and see me okay?
Yeah, I can. Perfect.
This is Nick Cram for the applicant, and I'm here with my partner, Katie Hill.
Okay, welcome. For Mass DEP?
Good morning, everyone. My name is David Bragg. I'm representing Mass DEP in this matter, and I'm with co-counsel Bruce Hopper and Ian Leeson, who are both with the Office of General Counsel.
All right. Thank you. Before go on, I just want to explain why Presiding Officers Rothschild and Grew are with me this morning. It's simply because I would like their input into this matter. Presiding Officer Rothschild, as all of you know, has lived with this matter far longer than me. And she was the one who has authored several opinions in this matter. And so I determined it would be worthwhile to get her input. And Presiding Officer Grew, he is a member of DEP's Office-wide Environmental Justice Committee. He is our representative on that committee. And although I am soliciting Presiding Officers Rothschild and Grew's input, I want to make clear that all the determinations that are made in this matter are mine. This is not going to be something that is subject to like a panel vote as an appellate panel. All the determinations, factual and legal, are mine. And just wanted to, explain that for the record. Now, the first thing that I wanted to address for the order of business is, Mr. Bragg, you noted in the department's closing brief that, and correct me because I'm paraphrasing right now, that you wanted an opportunity, or the department wanted an opportunity to address the misconduct claim that the petitioners have asserted against the department's sole witness, Christine Hops.
That's correct.
Okay. And so what I wanted to do was to deal with that issue first, because it is a very important issue. And when I say very important issue, doesn't mean I've made a determination yet on that issue, but it basically is a claim that is a serious one that has been asserted. And so what I'm going to do is first I'll hear from Mr. Hayden on behalf of the petitioners who have made the claim against Ms. Hops. And then I will hear from Mr. Cram to find out if Algonquin has a position on that claim. And then Mr. Bragg will come back to you for any kind of rebuttal or response. Okay. So, Mr. Hayden, as I understand it, and correct me if I'm wrong, but in the petitioner's closing brief, it is the petitioner's belief that Ms. Hops acted inappropriately by relying on her sworn pre-filed direct and rebuttal testimony when answering your questions on cross-examination. Have I accurately summarized the petitioner's claim?
Well, thank you, Mr. Chief Presiding Officer. It's certainly noted on page 12 of the petitioner's closing brief, as well as in footnote 6. I did not present a misconduct claim. The purpose of including that information in the closing brief was to reflect my clients, the petitioner's extreme frustration with the process in which Ms. Hops' review of this matter begun, was conducted, and ultimately was completed with her testimony during the evidentiary proceeding. I've never in my 20-year career seen a witness on the stand afforded an opportunity to review documents during the middle of their cross-examination. I understand the department's point, and it's one that I accept, that if a witness is presented with a document for review, then of course the witness is entitled to review the document for purposes of responding to a question on cross-examination when the document is called to the witness's attention by the examining attorney. This was something entirely different. This was the middle of the petitioner's cross-examination, where for all intents and purposes, the witness got down off the stand because we lost contact with this witness for technological reasons on more than one occasion. And then when the witness returned and was available for cross-examination, the witness made the point, unsolicited, that she reviewed materials during the time in which the technological connection was lost. So it was an extreme point of frustration for the petitioners. In the petitioner's mind, that should not have happened. The witness should not have reviewed any materials while stepping down off the witness stand, whether in person or via Zoom. And that was the reason for noting that development in the closing brief of the petitioners, but it wasn't anything more than that.
You're asserting it's not a misconduct claim. I'm just having difficulty following because it sounds like a misconduct claim to me.
Well, I guess, and I don't mean to interrupt you, Mr. Chief Presiding Officer.
Go ahead.
Okay. If it's a matter of semantics, I don't, in my mind, a misconduct claim would be brought to the Ethics Commission or would be briefed in full with a request for sanctions. The petitioners have not done that. The petitioners noted that conduct really in an effort to impeach the credibility of this witness. There's a lot of credibility determinations that Mr. Chief Presiding Officer will have. There's competing testimony, there's contradictory testimony, there's questions about the adequacy of the department's review. And, from the petitioner's perspective, the department failed to meet its obligations to conduct a full and complete review of this proceeding and this remand proceeding in accordance with the commissioner's remand order. And this was part and parcel to that.
I have a very quick question. Is there anything that was admitted to the record that you would say was improperly admitted to the record because she reviewed her pre-filed testimony during that outage?
Well, thank you, Mr. Grew. That's an excellent question and one that I will never be able to answer. The reason I can't answer that is because following the witness's departure from the Zoom link and after her review of whatever document she looked at when she was not connected to the Zoom feed, I can never know what her responses to my following questions would have been, but for her review of those materials. It deprived me of the opportunity to cross-examine her without, it's not a circumstance of a witness refreshing the recollection with a document provided by counsel. That obviously is permitted. This is a circumstance.
Excuse me, Mr. Hayden, excuse me. I don't mean to interrupt, but the only materials that I recall, unless I'm missing something, that you're objecting to that Ms. Hops relied on was her sworn, pre-filed, direct and rebuttal testimony. I don't think there's any assertion in your brief that she relied on any other materials in response to your cross-examination question. So I want to make that clear. Unless I'm missing something, I think the objection is that she relied on her previously filed, pre-filed testimony. And I think you admit it. That's what your brief says. That's what Mr. Bragg said in response. And Presiding Officer Grew, I didn't mean to interrupt your line of questioning, but I thought it was important to confirm what's being alleged in the closing brief.
I think it's a pertinent point. Thank you.
Okay,
Right,
Mr. Hayden,
Yeah.
I just want to confirm, you're not intimating that Ms. Hops was coached at all during those 2 periods when she was kicked offline?
I'm not. I have no evidence of anything that transpired other than what is in the transcript itself. And I did not attempt to sensationalize the transcript. I quoted it directly. So I merely pointed the chief presiding officer to what the transcript says and noted that in my experience, that's highly irregular and inappropriate.
Anything else, Presiding Officer Grew, Presiding Officer Rothschild?
No, thank you.
Anything else, Presiding Officer Rothschild?
No.
Nope. Mr. Cram, do you have a position on this claim on behalf of Algonquin?
The applicant's position is that absolutely nothing improper happened here. The department has made an effort to make these proceedings available to the public by conducting them over Zoom and broadcasting them over YouTube. The fact that Ms. Hops' connection was dropped twice during this process is just an unfortunate part of how this happens. In my experience in all of these proceedings, including in the proceedings related to this facility specifically, counsel begins the process by introducing their witnesses and asking them specifically, do you have a copy of the written pre-filed testimony that you submitted in this proceeding in front of you? And do you adopt it here for this proceeding? And we've always made sure that the witnesses do have access to their pre-filed testimony. And I think that's in part because we're dealing with a lot of technical and in-depth information and an incredibly voluminous record. And it would be nearly impossible to provide some of the detail in response to questions during a hearing without reference to it.
Anything else you want to add?
No, thank you.
Okay. Presiding Officer Grew, any questions for Mr. Cram?
No, thank you.
Presiding Officer Rothschild, any questions for Mr.
I have
Cram?
none. None.
Okay.
Thank you.
Thank you, Mr. Cram. Mr. Bragg, I'll turn it back to you for, I guess, a rebuttal or response to what has been said.
Yeah, I did refrain from objecting to some of the intimations that were made by Mr. Hayden, since we're not in that evidentiary hearing, but I think he just demonstrates a lack of familiarity with the process. As Mr. Cram pointed out, this is standard. Every witness who testifies at OEDR, the first thing they do is they adopt their testimony. They have it on hand for reference. And as a matter of fact, far from looking at other documents, and Mr. Hayden never made any hint of that until today, that he said it was a possibility. The only thing that Ms. Hobbs had was her pre-filed testimony. And in fact, she was looking at that pre-filed testimony when she was disconnected. So it wasn't like she was disconnected, went to review something else, and then came back. She was in the middle of being questioned about that paragraph, reviewed it during the time she was trying to get reconnected to answer the very question that she was being asked. So I think it's sort of outside the bounds of acceptable argument to intimate that there was something untoward going on her part. And I guess at best, and being most generous, I can just attribute that to a lack of familiarity with the process.
Thank you, Mr. Bragg. Mr. Ferguson, is there something you wanted to say?
Yes, Brian Ferraris from Mass DEP is requesting to enter the meeting, so I wanted to let you know, and if you will let
Sure.
me allow him in, I will do so.
Sure.
And can I also ask, there's one person present who did not identify himself. I can't read the full last name, but the first name is Jared.
Yeah, he is the new general counsel for the LSP board. My apologies for not introducing him earlier.
Thank you.
Mr. Bragg, perhaps, Mr. Hopper, yes?
I just want to add, I'm Bruce, I'm the litigation manager for Mass DEP. I understand Attorney Hayden and his clients are frustrated with the process, but that by no means provides an excuse to impugn somebody's character and, by implication and directly throughout their brief. So I'm just here to voice my displeasure on how this went down.
Thank you, Mr. Hopper. Unless there's something else you wanted to add. Is that it?
No.
Okay. All right. Mr. Bragg, you can resume unless you believe you've concluded. Your Mr. Hopper's comments dovetail with yours. As I understand it, the department is not happy with the allegation made against Ms. Hops. Is that fair?
That's correct.
Summary.
And I would reiterate, she did nothing improper. She handled herself quite well under difficult circumstances. No one likes to be on the short end of the internet signal stick when it comes to these sorts of hearings. It was a difficult situation for her, and she was actually trying to be a good witness and answer the very question she was being asked. So she had her pre-file testimony in front of her, as is the normal procedure for OADR evidentiary proceedings, and that was the only material she had.
Anything else you want to add?
No, that's it.
Mr. Hopper, anything else you want to add?
I appreciate the opportunity for us to argue on just what was written is a public document, and Ms. Hops, who has outstanding character, has great experience, and just again, it's upsetting that her character again was smeared in a public document unnecessarily.
Thank you, Mr. Hopper.
Thank you.
Presiding Officer Grew, any questions for Mr. Bragg?
Just one. In your experience in other matters, have witnesses sort of on their own initiative reviewed their pre-filed testimony as part of testifying?
If it helps them to answer a question they've been asked, if they think that there is some relevant paragraph in their testimony, because their pre-filed testimony is supposed to be sort of the four corners of what's allowed on cross-examination, they will refer to it sort of on there. They don't have to be directed to a specific paragraph by the questioner, although often they are.
So in this instance, really the only difference is that there had been a disconnect in the middle.
I believe so. That, nothing really would have changed had the connection remained stable. She would have been referring to her own testimony, which is really standard practice and what is expected of witnesses in these proceedings.
Thanks.
Mm-hmm.
Anything else, Presiding Officer Grew?
No, thank you.
Presiding Officer Rothschild, any questions for Mr. Bragg?
I don't. I just want to respond a little bit to what Mr. Hopper said, and rereading, and I'm looking at the petitioner's closing brief. I don't believe Mr. Hayden and his clients smeared Ms. Hobbs. They made a statement that they believed her conduct as a witness on the stand was inappropriate and irregular. And as Mr. Hayden explained, I don't think that they smeared her character. And I think that's a little overboard in this. And I think Chief Presiding Officer Geraldine Dino will respond to that. But I think Mr. Hayden explained what he was getting at. I don't agree that it was character assassination that he was going for.
Anything else, Presiding Officer Rothschild?
No.
Yeah. If I could respond quickly to that,
Sure.
I actually believe, in my statement that at best this could go down to simply a lack of familiarity. So I take Presiding Officer Rothschild's point. It could just be unfamiliarity with how OEDR proceedings operate. And so I do leave that as a possibility, though I still object to the implications that were present in that footnote. So thank you.
And with that point, I'll say that sometimes the lack of familiarity with the process results in harm. And although I agree, with Presiding Officer Rothschild, that I don't think there was an intent to smear Ms. Hobbs, but the fact of the matter is there is a lack of familiarity with the permissibility of using pre-filed direct and rebuttal testimony by a witness while being cross-examined in an adjudicatory hearing. I have been the Chief Presiding Officer of Mass DEP's Office of Appeals and Dispute Resolution for more than 16 years. And this is the first time that I have heard any party question a witness's use of direct or rebuttal pre-filed testimony. First time. Because the biggest difference between adjudicatory hearings before OADR and in court is because we have a system of pre-filed direct and rebuttal testimony. In court, and I know what happens in court because before I came to DEP, for 20 years, I was a trial and appellate attorney. And the biggest difference regarding a proceeding in court is that there is no pre-filed direct testimony. Unless the witness has been deposed in a civil proceeding, nobody knows what the witness is likely to say on the stand. And so, because of the importance to really address this issue sooner than later, meaning in my recommended final decision on remand, I will state at this juncture that in my recommended final decision, I'm going to recommend that Commissioner Heupel reject the claim. So I think we have discussed this enough. Does everyone agree?
Yes.
Okay.
Thank you.
Yes.
So let's get to now the merits of the controversy. And so we're here because the petitioners have challenged Mass DEP's second determination, the determination of the Chapter 91 program, that the compressor station at issue, which I stated earlier is located on Phil Thailand's in the Fore River and Weymouth, is an ancillary structure or facility to the hub line within the meaning of the Chapter 91 regulations at 310 CMR 9.02. I think we're all in agreement about that. That's what the evidentiary remand hearing I conducted several months ago in October was about, that the parties presented expert witnesses on each side with respect to their respective positions on whether or not the determination was correct. And so for the benefit of individuals who are watching this on Mass DEP's YouTube channel. It's probably a good idea for me to summarize how we got here, the prior history. First off, I think we begin with the regulation at issue 310 CMR 9.02, which deals with ancillary facilities to infrastructure facilities. And the definition of what an infrastructure crossing facility is, or actually includes, is a pipeline which is located over and under the water and which connects existing or new infrastructure facilities located on the opposite banks of the waterway. Now, I have zoned in on one particular part of that regulation because that regulation is quite long, but I think that's the pertinent one. Council agree that's the pertinent provision that I'm looking at? And the same regulation says that any structure which is operationally related to the infrastructure crossing facility and requires an adjacent location shall be considered an ancillary facility to the infrastructure crossing facility. So it is the second part of that definition, the word requires, that also finds us here today. Is everyone in agreement? Council agree with that? Okay. And so the question presented for me to adjudicate is whether the compressor station is an ancillary facility, specifically a facility which is operationally related to the hub line, but requires an adjacent location to the hub line. I'm not going to really focus on whether or not it's operationally related. I think the evidence has shown that it is operationally related. But the big dispute is whether or not it requires an adjacent location to the hub line. That is the major dispute between the parties. Am I correct? With respect to the interpretation of this regulation, 310 CMR 902? I see heads nodding by council, so I will assume that's a yes. So can you folks say yes for the record? So
yes, from the applicant's perspective.
Yep. And the department and the petitioners, please.
Yes, that's an accurate summation of where we are.
Okay.
Mr. Chief, Mr. Chief Presiding Officer, the petitioners do not waive an argument as to whether or not the compressor station is operationally related.
Okay.
To the hub line.
Well,
I agree that as constructed, it is. But
okay.
Given that this proceeding is not a review isolated to the compressor station, but is a review of the previously licensed infrastructure crossing facility that is the hub line, the petitioners have an argument and testimony to support that had this compressor station been either not constructed or constructed elsewhere, that it could still facilitate the Atlantic Bridge project without being operationally related to the hub line, which is just this bank-to-bank structure. And you've taken my opening paragraph from my closing argument when it begins, because I was going to read the quote that you have already read from 310 CMR 9.02 with regard to the opposite banks of the waterway. That's all the hub line is. It's just a bank-to-bank structure, and the compressor station does not need to be operationally related to that bank-to-bank structure. But I do agree with you. The principal focus today is whether or not the hub line requires the compressor station to have an adjacent location.
Okay. And I'll note the fact that you're not waiving your argument. However, the remand to DEP was governed by the Superior Court's judgment in this case, which focused exclusively on the word require. the Superior Court ruled that my esteemed colleague, presiding officer Rothschild, although did not mention her by name, applied the incorrect definition of require. I'll get into that in a minute as what the Superior Court did, but Superior Court really did not concern itself, and I have the decision right in front of me. I have read this decision at least 5 times or more to make sure that I know of it, top to bottom. The Superior Court was really concerned about the definition of require, and did not really show any concern about any other issue. So I want to make that clear,
And I agree with that.
Okay. And so we are limited to what the Superior Court did in its remand order. And in its remand order was that the court sent it back to DEP to reassess whether or not the compressor station is an ancillary facility using the court's definition of what requires means. That's what the Superior Court did. And so to continue with the prior history, I don't think I need to go over about the original ruling, because I think I summarized that there was an original ruling made by my colleague, presiding officer Rothschild, 4.5 years ago, which was adopted by the then commissioner of DEP, finding that the compressor station was an ancillary facility to the hub line within the meaning of 310 CMR 902, because the facility required an adjacent location to the hub line. That was adopted by former Commissioner Suberg, and in a final decision, which then was appealed to Superior Court, and I just summarized what the court did. And to get a little bit more into the details of the Superior Court's decision, the Superior Court disagreed with the application of the definition of required, because according to the court, it was an incorrect definition of the word require in making the determination. Specifically, the court said that the definition of the word requires, and I'm quoting from the decision, means that something is required, demanded, or made necessary because it is suitable or appropriate. That was the definition that the court required DEP to use on remand in assessing whether or not the compressor station is an ancillary facility within the meaning of 310 CMR 9.02. And so, in response to the court's order, former Commissioner Suberg remanded the matter to presiding officer Rothschild, and presiding officer Rothschild, based on the evidentiary record that was before her from the evidentiary adjudicatory hearing that she had conducted previously, which resulted in her determination that the compressor station was an ancillary facility. Based on the record, the evidentiary record that was before her, and utilizing the definition of requires directed by the Superior Court, she determined that the compressor station is not an ancillary facility to the hub line. And in response to presiding officer Rothschild's determination, then Commissioner Suberg, Mass DEP Commissioner Suberg, remanded the matter for further Chapter 91 license review, remanded that to the Chapter 91 program. And during the re-review or further review, whatever you want to call it, Algonquin presented additional evidence in support of its claim that the compressor station is indeed an ancillary facility to the hub line in accordance with 310 CMR 3.2. In response to that determination by the, in response to that additional evidence and applying the court's definition of requires, the Chapter 91 program determined that the compressor station is an ancillary facility to the hub line. And that's where we find ourselves today, because as a result of the petitioner's challenge of that determination, I conducted an evidentiary remand hearing this past October, where, as I indicated earlier, the parties presented expert witnesses in support of their respective positions on the Chapter 91 program's determination on remand. And at that remand hearing, the petitioners opposed the determination, claiming it was erroneous. Algonquin and Mass DEP argued that it was correct. So today, in a few minutes, we're going to get into or hear the closing oral arguments from the parties' respective counsel in support of the parties' respective positions on whether the Chapter 91 program's redetermination was correct or not. So that's why we're here. I think it was important. I know this is a lot of information, but I think given the history and the prior history proceedings in this case, it was important for me to recite what had transpired previously. So now, before we get into the oral arguments, I think it's important to go over the standard of review that governs my review of the Chapter 91 program's determination that the compressor station, determination on remand. I want to make clear that's what I'm talking about. Determination on remand that the compressor station is an ancillary matter, is an ancillary structure, to the hub line. And so, to be brief on the standard of review, it is a de novo, neutral, and independent review by me, the presiding officer in the appeal, to review the determination that the program made on remand. And it has to be a neutral and independent review because due process principles require so. There are a number of cases decided by the state Supreme Judicial Court and the appeals court making clear that the obligations of hearing officers, which presiding officers, administrative hearing officers, which presiding officers are to be independent. The next rule with respect to the standard of review that a presiding officer follows is that the presiding officer owes no deference whatsoever to prior factual determinations made by the department. By regulation, the factual determinations made by the presiding officer rest with the sound discretion of the presiding officer, meaning the presiding officer's factual determinations stand unless they are clearly not supported by the evidentiary record in the appeal. The next rule regarding the standard of review is that a presiding officer owes deference to reasonable interpretations made by the department of policies, regulations, and statutes that the department is responsible for enforcing. If the department's interpretation or construction or application of a policy, regulation, or statute is reasonable, the presiding officer is required to accord deference to that interpretation, construction, or application. However, the other rule that goes with deference is that deference is not abdication. That in determining whether or not DEP's determination, legal determination, or application of the policy, regulation, or statute is reasonable, presiding officer has the authority and should exercise the authority to ask the pointed and sometimes difficult questions to reach the position of the determination of whether the department's determination is a reasonable one. And the last rule for the standard of review, that whatever I or any other presiding officer does in an administrative appeal, it is a recommended final decision. The ultimate decision maker in the appeal is the Commissioner of DEP. And I can represent to you that Mass DEP Commissioner Bonnie Heupel takes her role as the final decision maker in administrative appeals very seriously, like the commissioners before her. And so when she gets this case to review, she'll have my recommended final decision on remand, however that comes out, along with the evidentiary record in this case, along with it will be available a recording of this Zoom oral argument of counsel, and also it will be on Mass DEP's website as part of the Mass DEP YouTube channel collection. And so that is what governs, in summary, what my review here will entail. And so I think the process that I want to follow here is, Mr. Bragg, I'm going to have you go first. And then I'm going to have Mr. Cram go next for Algonquin. And then I'll have Mr. Hayden go last, with an opportunity for rebuttal argument afterwards. And the reason why I'm having you go first, Mr. Bragg, because it makes sense from my point of view as the adjudicator, presiding officer here, to make the determinations, for you as the department's counsel to summarize the additional evidence that DEP has argued in its closing brief and argued at the remand hearing, the additional evidence that was presented by Algonquin that led to the program determining, again, that the compressor station at issue is an ancillary structure or facility to the hub line within the meaning of 310 CMR 9.02. Before you start your presentation, I just want to get confirmation for my benefit, because I believe I'm correct, that the additional evidence consisted of, among other things, analyses of potential alternative sites for the compressor station and potential environmental consequences of locating the compressor station in those locations. Am I right? Am I correct?
That's correct. It was a full analysis by the waterway staff on that question.
Whether or not it was a full analysis, that's up to me, for me to be argumentative. All right. However, but the bottom line is you have confirmed that the additional evidence included that analysis of the alternative sites. And so as I understand it, when DEP applied the court definition of requires, as I discussed previously, right, that DEP determined that in the calculus of deciding what is required, if the compressor station required an adjacent location to the hub line, that within the calculus of required are potential environmental consequences of alternative sites. In other words, an alternative, environmental consequences of alternative sites is a rational, reasonable thing to include in the calculus of determining of whether it's required or not. Am I correct in stating the department's position?
That is correct, yes.
Okay. And so could you first argue for me why that's a reasonable, and when I ask these questions, this is not an indication of where I stand. It is part of what I said before, my authority to ask the important questions to get to the determination of whether the department's construction of the regulation was reasonable. Okay. So if you could summarize why that additional evidence, summarize the additional evidence of the alternative sites and the environmental consequences, the alleged environmental consequences, why it is reasonable for the department to include that in the calculus, as I indicated before, of the definition of requires. So I'll let you argue, and then I'll turn it over to my colleagues if they have any questions. So are we clear? We're fine with that? I know I mentioned, all right, thank you. Go ahead.
Makes sense. All right. Thank you, Mr. Giorlandino.
Yep.
I will open up. I do appreciate you clarifying one of the issues here, and it really does come down to the interpretation of that reg, the proper interpretation. And that is the compressor station is an ancillary facility to the hub line infrastructure crossing facility because it's operationally related. So not operationally integral, not operationally essential, but operationally related to the hub line. And it requires an adjacent location to the hub line because this avoids unnecessary adverse impacts to Chapter 91 jurisdictional tidelands while operating in the most efficient location. So when we look at whether or not something is required, we look at a kind of a broad array of questions. And the proper framework is not, is it absolutely impossible to put it elsewhere? Because if that were the standard, it would really preclude the application of this definition in all cases. We need to look kind of holistically. What is the site? It's a DPA, designated port area, which is designated so as a suitable and appropriate place for marine industrial activity. The adjacent location allows for all of the services that the compressor station provides to the hub line without any additional adverse impacts to Chapter 91 jurisdictional lands. I don't have all of the figures memorized. I know it varies from the distance of a mile all the way up to 30 miles and many acres of disturbance of Commonwealth tidelands that would be entailed in any of the alternate locations. And the department, part of our responsibility under Chapter 91 is to consider impacts to Chapter 91 jurisdictional lands and to avoid unnecessary, I would even use the word gratuitous, adverse impacts to these natural resources, to these jurisdictional tidelands. And so I think when we looked at the full range of alternate locations and engaged, as the Waterways Program technical staff engaged in a full analysis of the information presented by Algonquin, and this, I will admit, was something that Presiding Officer Rothschild did not have the benefit of in the original hearing. I think she even noted in her recommended decision that the department just sort of took the applicant's word for it, and we didn't engage in that extra sort of independent analysis that we believe is kind of determinative here. Once we did undertake that analysis, looking at all of the impacts that would follow from an alternate location, we determined that the location at the site already in industrial use, already part of the infrastructure crossing facility without the need to disturb, a square foot of jurisdictional tidelands in another area, that it was the appropriate location and was required to be there.
Anything else you wanted to add?
I would add one other thing. In addition to, I believe, sort of conflating the application of the word required to describe the relationship, many times in their briefs and in their arguments, they say the hub line doesn't require the compressor station, therefore it can't be an ancillary facility. I believe that's the improper standard. I believe you correctly stated that it's really operationally related is the key phrase when you're talking about the relationship between the infrastructure crossing facility and its ancillary facility. And the word required really only enters the equation on that second prong of, does it require an adjacent location? So the question was never, does the hub line require the compressor station, even though the petitioners expended a lot of effort going down that path? I believe it is not relevant to the proper reading of the regulation. And another piece that they put a lot of stock in is a very similar case to this one, which was somewhat parallel, the East Eagle electrical substation. They referred to it many times, and they stated that an electrical substation absolutely has to be next to its parent facility. It could never be located somewhere else. And that's why it's listed as an example of an ancillary facility. But if you look at the EFSB, the Energy Facility Siting Board, preceding an East Eagle and their final determination in that case, it was quite apparent, and really the much like this matter, the central question in East Eagle was, why not put the substation somewhere else? Because it's technically feasible to do so. The EFSB properly concluded that if we apply a standard of if it can possibly or even theoretically be located somewhere else, that precludes it being qualifying as an ancillary facility. Nothing would ever qualify as an ancillary facility. So we believe that the same rationale that the EFSB applied to East Eagle, that the petitioners sort of improperly relied upon because they presented the East Eagle substation as distinguishable from the compressor station in that substations could never be at a distance from their parent facility. We think that same calculus should apply here, where you can't have a standard that's so impossibly high that no facility could ever meet it, because you can always argue it's theoretically or feasible in some manner to locate it somewhere else. And another troubling piece of the petitioner's push is sort of a total disregard of the environmental impacts that would be entailed. They seem to indicate it was improper of us to consider the environmental impacts to Chapter 91 jurisdictional tidelands when looking at the sort of total costs of these alternate locations. So we believe that we properly applied the regulation. We believe we were consistent in this case with the rationale provided and followed by the EFSB in the East Eagle matter. And again, substations are actually one of the listed examples under the definition in 902. And so to say that, the substation under the rubric of if it's possible to be somewhere else and it can't be an ancillary facility, that really would render that definition meaningless, because even a listed example wouldn't qualify, wouldn't pass muster. So we believe that would be sort of an illogical result, and we believe it would sort of render the entire concept of the ancillary facility under the definition of infrastructure crossing facility. It would render it meaningless. And then briefly, I would point out that the same structure requires a certain location. That's not just for ancillary facilities to infrastructure crossing facilities. It has a much broader use in Chapter 91. When the waterways program makes a determination of water dependency under 912, the same language is used. Does it require a location close to the water? And if we were to sort of tighten up require to the point where it means impossible to be anywhere else, then many of the listed examples under 912, including aquariums, boat yards, things that could feasibly and technically be located away from the water, they would no longer qualify as water dependent uses. And the department believes that would be completely contrary to the intent of the regulations and to the broader Chapter 91 regulatory scheme. And it would cause sort of a cascade of unintended consequences.
Thank you. Was there anything else you wanted to add?
Nothing at this time, but I'm happy to follow up with any specific questions you might have.
Before I turn it over to my colleagues, presiding officers Grew and Rothschild, for any questions they may have for you, I have one question, and that is, I take it then the department does not have any issue with presiding officer Rothschild's previous decision, the one that she issued from the remand order that former Commissioner Suberg directed her to reassess whether or not the compressor station was an ancillary facility based on the court's definition and on the record that was before her, evidentiary record. So if I understand the department's position, you don't claim that was an error, that it was a reasonable determination of presiding officer Rothschild to make based on the evidentiary record at the time.
That's correct. We agree that we don't believe Presiding Officer Rothschild had the benefit of the full analysis of the department of the waterway staff in her prior proceeding. I will have one caveat. One phrase in the recommended remand decision that I think just may have gotten a little conflated, and this was in the context of a lot of argument, a lot of effort by the petitioners to push this theory. At one point in the recommended remand decision, it talks about the gas compressor station not being integral to the operations of the hub line. Again, I agree with the way you laid it out at the beginning of this proceeding, which is the question isn't, is the gas compressor station integral or essential for the hub line to operate? The question on the relationship between the two is, are they operationally related? The word required does not enter into the equation until you get to, does it require an adjacent location? So I think that's the one piece where I think I would disagree. And I think it was just simply in the context of lacking that independent analysis from the department. So not having sort of the benefit of the department's analysis before her in that earlier hearing. And that didn't come into play until after the commissioner's interlocutory remand order. And with the new determination, I think it was about 1 year ago today. And again, a kind of a really long train of misstating or conflating the word required and sort of expanding required to apply to the entire definition, which we believe is sort of an incorrect interpretation by the petitioners. But yes, in general, I do agree that Presiding Officer Rothschild reached the correct conclusion based on what she had before her, when she did not have the benefit of that independent analysis from the Waterways Program on the need to have the adjacent location.
Thank you. Presiding Officer Grew, any questions for Mr. Bragg?
Yes, just a couple. So the first is really going to the scope of the Superior Court's remand. Are you contending that this review is any broader than the issue that we've been discussing, the meaning of the term required in this context?
No, I actually, and in my closing brief, I cited to sort of the guardrails that apply when it's been remanded from a court back down. You really can't go beyond the scope of what the court is asking you to examine. And the court was very specific in this case. It asked for a full examination of the word required, with taking into account an element of necessity. To paraphrase the court, I think it boiled down to you can't have required simply mean is. You can't say it requires adjacent location because it has an adjacent location, so that's appropriate. There has to be some element of need or a rationale to support it. Why is it there? Why is that the appropriate location? And I believe the court was correct in sort of asking for that sort of fuller analysis under required and not allowing DEP to sort of water it down and just say, if it's there, it's appropriate, therefore it's required. There has to be that element of need. But again, sort of to turn back to the caution against interpreting required as absolutely necessary, absolutely impossible to be elsewhere. If we go so far to the other extreme from sort of the watered down version of required that the Superior Court did not buy into, I think we run a risk of overcorrecting and almost rendering this regulation, not to mention the larger scheme of water dependent uses, sort of kind of throwing them into limbo. Because to quote the EFSB, if it's theoretically possible to be somewhere else, then you're saying it's precluded from being an ancillary facility, and that would be a result we think that would really be incorrect.
So next, looking at, and I was looking at Mr. Paquette's exhibit 1. This is the Epsilon report. There's a, kind of fulsomely dissects the other potential placement sites and the environmental effects. And he doesn't just limit it to tidelands. He also looks at wetlands, endangered species, vernal pools, water quality. There's 6 or 8 different categories. Did the department, in its analysis, did it take any of those effects other than the tidelands into account, or was it narrowly focused on the effects on the tidelands by alternate placements?
Sure. We focused on, since this is a waterways review, we did focus on Chapter 91 jurisdictional tidelands, but the regs at 310 CMR 9 make it clear that the waterways program is not indifferent to environmental impacts to other resource areas, including wetlands, including these natural heritage sites. So it's important to look at it in the full context. Here, we weren't sort of arguing against an applicant who was trying to place a facility in another area that could cause that kind of unnecessary adverse impact. So we didn't really have to get into it, but certainly 310 CMR 912 2D does give the department the discretion to include impacts to various environment. I think the exact term is adverse impact to the environment. So that's broader than just jurisdictional tidelands. But in this case, because the unnecessary impacts of tidelands was quite obvious, and the applicant was not pushing to place the compressor station in one of these other locations that would cause this sort of unnecessary and gratuitous adverse impacts, we didn't need to invoke 912 2D, but it certainly highlights that even in the Chapter 91 context, when you're talking about a DPA, you're talking about marine industrial uses, you're talking about sort of an economically focused statute, it's not indifferent to environmental impacts.
And so last question, Chapter 91 derives ultimately from the public trust doctrine, which says that the Commonwealth is a fiduciary of all the Commonwealth's tidelands. And in terms of interpreting the word required, is there any indication that you've seen in the regulations where the department intended in promulgating that regulation to kind of abrogate that fiduciary obligation?
No, I think it's quite the opposite. When you're looking at the word required in this context, does it require an adjacent location to avoid these unnecessary impacts? That's very much in the spirit of those public trust fiduciary responsibilities that the department has under Chapter 91. So I believe it sort of goes hand in hand with that trust and protecting those Commonwealth jurisdictional tidelands from sort of gratuitous adverse impacts when looking at the possible locations for the structure.
Okay, no additional questions on my end.
Presiding Officer Rothschild?
I just have one question for Mr. Bragg, and it's to what extent does the Waterways Program owe deference to the Federal Energy Regulatory Commission, FERC, or the Energy Facilities Siting Board, EFSB, and its siting decisions in making its determinations under this regulation?
I believe when we're making our determinations under Chapter 91, it's a different question than FERC. So I don't believe we defer to their sort of technical determinations in terms of where it's possible to locate it. I believe perhaps the reason that the department did not provide enough evidence in the initial hearing, our waterways analysts are not, fluid dynamic engineers. They're not really qualified to go into the minutia of where a compressor station can be feasibly located and what are the engineering and technical aspects to where it could be located. They are looking at the lens, as Presiding Officer Grew mentioned, of that fiduciary responsibility to protect tidelands. So I think, some of the decisions made by the EFSB are actually somewhat reverse. The EFSB, when it is issuing a comprehensive approval, it sort of stands in the place of DEP, and it's supposed to sort of, I guess you could say, ask itself, what would DEP do? And so I believe that they did properly engage in that analysis in East Eagle, and that's why, given the petitioner's multiple references to it, I felt comfortable citing to the EFSB. But in terms of direct deference, I think FERC is certainly concerned with different issues than the Chapter 91 kind of fiduciary responsibility to the public trust that DEP has. And as far as the EFSB goes, when they are applying Chapter 91, they're really supposed to do it in a manner that's consistent, or they're trying to stand in our place when they're issuing these comprehensive approvals under the EFSB process.
So it's possible that if FERC makes a certain determination on siting, and they've got the benefit of something like Resource Report 10, which details a lot of the environmental impacts, the department could come to a different conclusion than FERC did. Is that correct?
It's possible to. I believe in this case, when the waterway staff looked at the impacts from other locations, we agreed that the other locations did have these adverse impacts that were unnecessary and therefore could be avoided by having the adjacent location. But yes, it's theoretically possible that we would make a different determination. I couldn't really think of a hypothetical right now, but it would be possible that we might disagree with FERC because we simply are asking different questions. We're looking at it from a different perspective.
Thank you. That's all I have.
Thank you. Mr. Cram? And what I would request, I've taken under advisement Algonquin's arguments in its closing brief with its disagreement with presiding officer Rothschild's previous ruling. And so what I would like is just to continue the discussion we started with Mr. Bragg regarding the additional evidence that was presented to the Chapter 91 program on remand, and the whether or not the department's construction, interpretation, application of the regulation at issue regarding ancillary facilities was a reasonable one. So that's what I would request that you focus on. And again, taking everything else under advisement that is in the brief.
Okay, thank you for that. And I'll try not to restate what we've heard from Mr. Bragg, because the applicant very much so agrees with the department's interpretation of its regulation as set forth in Chrissy Hop's testimony. And indeed, not only do we think that the department's interpretation of its regulation, current interpretation of the regulation, is reasonable, we think it's the only permissible one when you consider the general mandates that apply to the department and the specific regulatory scheme in which this provision falls. And so first, I just start again with the definition that the Superior Court has asked the department to apply. It's when you're examining whether or not something requires an adjacent location to an infrastructure crossing facility, the question is whether or not the location is required, demanded, or made necessary because it is suitable or appropriate. And that clause, because it is suitable or appropriate, is an important one. The Superior Court did not say that when you're determining whether or not something requires an adjacent location, you're to ask whether or not you could possibly put the facility somewhere else. Instead, it's dictated a more nuanced analysis by specifically including suitable and appropriate. So then what is the department supposed to do in figuring out exactly what that analysis means? And the starting place is in the regulations themselves, and specifically the provisions that concern ancillary facilities. And Section 310 CMR 912 2D, which Mr. Bragg talked a little bit about, or the general water dependency provisions, specifically says that whether an ancillary facility can be reasonably located or operated away from tidal or inland waters, that's exactly what we're talking about here, whether it can be in Commonwealth tidelands or put somewhere else, shall be based on a comprehensive analysis of alternatives and other information, analyzing measures that can be taken to avoid or to minimize adverse impacts to the environment. So there, the regulations specifically give the department guidance as to what they should consider. And one of the things that they should consider are avoiding and minimizing impact to the environment. And what Algonquin has demonstrated through the Paquette testimony and the very in-depth analysis that he supplied in the Epsilon report is that by locating the compressor station at its existing site in Weymouth, the applicant and the department has avoided and minimized adverse impacts to the environment associated with all of the other sites, including specifically to flowed tidelands, all of which would be impacted with respect to locating the site at any of the other locations. In addition to 912 2D, there's a general mandate in General Law Chapter 3061, which provides that unless a contrary intent is manifested, all statutes should be administered and interpreted so as to minimize and prevent damage to the environment. So here the department is acting under a general mandate that all of the decisions that it is making and all of the considerations that it undergoes have to take into account minimizing and preventing damage to the environment. And that's precisely what it's done here. And then the other provision that I didn't hear Mr. Bragg cite in his argument today on Zoom, but that is in his brief, is also that specifically 310 CMR 33, also in the Chapter 91 regulations, specifically says that all Chapter 91 projects must comply with environmental regulatory programs of the Commonwealth. And so when you factor all three of these things in, and also the various policy considerations and the sort of chaos that a more limited interpretation of required would bring, it becomes quite clear that the department was very reasonable and in fact really has a mandate to consider the impacts to the environment and to the Commonwealth's tidelands and flowed tidelands in making its determination. The current location in Weymouth is, under the definition that the court has asked the department to apply, required, demanded, or made necessary because it is suitable or appropriate in light of all of the impacts that it avoids, specifically including to tidal waters and environmental resources. You know, you had asked before, and I'll be very brief on this because I hear you that we've made the arguments in our brief, but you asked before about the department's view of Presiding Officer Rothschild's decision on remand. And I just reinforce that it's the applicant's position that it is your role in this proceeding to make a de novo review and not to be swayed by what's happened before. Certainly you should understand the history of how we got here, but that you should be making your determination anew. And it is the applicant's position that Presiding Officer Rothschild did not interpret the regulation correctly at that time, but she did not have the benefit of the department carefully explaining in its testimony how it interprets the regulation and why, and it has now done so. And the place that is really evident is that there's a place in the remand decision that Presiding Officer Rothschild issued that explains that what the Superior Court had asked her to do is define requires to mean that something is suitable or appropriate because it is required, demanded, or made necessary. And that really explicitly reverses the language that the court had asked the department to apply, and in doing so substantially changed its meaning.
Is there anything else you want to add?
On the interpretation of the regulation? No, thank you.
Presiding Officer Grew, any questions from Mr. Cram?
Just one, and the same one that I had asked Mr. Bragg. Does the applicant have a view on the scope of this remand? Is it broader than the definition of the word requires as applied in this instance?
No, that's the central focus of what the court has asked the department to do. It's to consider what that word means and then to apply it, and in doing so consider the impacts to the environment and other tidelands that would be associated by putting the compressor station somewhere else. I guess there is one other thing. We think that the department has interpreted its regulation correctly, and that the analysis should involve a detailed review of the impacts associated with the alternatives. But there's also another issue here, and that is that this compressor station, in a really fundamental sense, before you even get to consideration of impacts to the environment and tidelands, also requires a location adjacent to the hub line. And that's because it needs to connect to the hub line to provide the necessary pressure to move gas from the I-9 and from south and west of Weymouth to the north through the hub line. If you look at all the alternatives that were considered, in each instance, every single one of them involves a discharge pipe that moves compressed gas back to and connects directly to the hub line. So where it's true that you could technically locate the compressor unit at some far off location from the site in Weymouth, in each instance, it's going to require up to 30 miles of discharge pipeline to connect all the way back to the hub line to provide the necessary pressure to move the gas. And so when the compressor station was licensed, it was licensed to include the compressor unit and the suction and discharge pipes that connect to the system. Where it's currently located, those suction and discharge pipes are entirely contained within the site, and a very short link till you get to the hub line. But when you pull it away, they become very long and very impactful, but still in every instance, they're a part of the compressor station and they have to connect to the hub line. So in every instance, they still require fundamentally an adjacent location to the hub line.
Okay, thank you.
Thank you.
Presiding Officer Rothschild, any questions for Mr. Cram?
Mr. A similar question to what I asked Mr. Bragg, and Mr. Cram, I'll just let you know, I take no offense to the statements in your brief. But
Thank you.
In the applicant's perspective, given that it's come up not only in this case, but came up in the air permit as well, to what extent, if any, does the department defer or should defer to determinations made by FERC and the EFSB?
In this case, I think FERC's siting determinations will ultimately be controlling, but they are entirely lined up with the way that the department has viewed this analysis as well. So we don't, at this stage, need to make that determination. I mean, it certainly is another factor that FERC has found that this is the appropriate site for this facility and has authorized it. And it goes into the calculus of whether or not it could be put somewhere else. So I think ultimately FERC is going to be controlling on this issue. But here we don't need to determine what that means because FERC's determination and the department's determination are really entirely lined up.
But there could be an instance where they do not line up, correct?
Yes, I think that's possible. And then it would bring in a different question as to, the exact significance of FERC's siting determination. And we believe that ultimately it would be controlling.
But I think that in this instance, Chief Presiding Girolandino is concerned that the department is doing its job in reviewing the project under Chapter 91, irrespective of what FERC determined.
We appreciate that, and the analysis comes out exactly the same because we're considering many of the same things. But here, in addition to what FERC had the opportunity to review, we've really supplemented the record and provided a very detailed analysis of the impacts that are specific to the Commonwealth. And the analysis that Mr. Paquette has provided through the Epsilon Supplemental Alternatives analysis is very similar to what you would see in a MEPA context and very specific to Massachusetts.
Thank you. That's all I have.
Thank you, Presiding Officer Rothschild. Mr. Hayden, your turn.
Thank you. I'd like to start by revisiting the definition of infrastructure crossing facility that you began with, Mr. Chief Presiding Officer, under 310 CMR 9.02. In this instance, that definition applies to a pipeline that connects existing or new infrastructure facilities located on the opposite banks of the roadway, of the waterway. And that's it. It's a bank-to-bank definition. An infrastructure crossing facility is not defined to include a multi-state natural gas pipeline project. This is not a question about the Algonquin gas pipeline. This is a question about the hub line and its operation from bank to bank. The 10 examples of ancillary facilities that are also listed in section 9.02, which include power transmission substations, gas meter stations, sewage headworks, and pumping facilities, toll booths, tunnel ventilation buildings, drainage structures, approaches, ramps, and interchanges which connect bridges and tunnels to adjacent highways or railroads. There are countless examples of all of those ancillary facilities all around the Commonwealth. They all require an adjacent location to their infrastructure crossing facility, and they're all operationally related. There is no other example of a natural gas compressor station as an ancillary facility to any infrastructure crossing facility in the entire Commonwealth. This is a first unicorn type request. There is no long-standing precedent by this department or any other agency in Massachusetts defining a natural gas compressor station as an ancillary facility to a hub line. There are also no other examples in the entire Atlantic Bridge project of compressor stations in jurisdictional tidelands. This is it. This is the one and only instance where this applicant has ever sought to construct a natural gas compressor station in a jurisdictional tideland, and it's the first instance when this department has been asked to review whether or not the compressor station meets the definition of ancillary facility. Now, the hub line is an infrastructure crossing facility because it connects existing or new infrastructure facilities located on the opposite banks of the waterway. The purpose of the hub line is to transport natural gas from bank to bank. Again, by definition, that's all infrastructure crossing facilities do. Bridges cross rivers, tunnels burrow underneath the harbor. In every instance, the purpose of an infrastructure crossing facility is to connect existing or new infrastructure facilities located on opposite banks of the waterway. Nothing less than that, but importantly, nothing more. It is not the department's concern whether after a car crosses a bridge, it can then drive to Maine or Canada. It is not the department's concern after utilities pass through a tunnel and reach the bank at the opposite end, whether those utilities can continue to Maine or Canada. That is not the function of an infrastructure crossing facility. Of course, no bridge or tunnel in Massachusetts takes people to Maine or Canada. The single biggest misrepresentation in this entire proceeding has been the design specification between the I-9 pipeline and the I-10 hub line. There is no pressure differential to overcome between the I-9 pipeline and the I-10 hub line. Natural gas can move freely in both directions, north and south, through the hub line, because the maximum operating pressure on the I-9 system is 1,250, and the maximum operating pressure on the I-10 hub line system is 1,440, which for engineering purposes means there is no pressure differential that interferes with the flow of gas in either direction. The hub line has been transporting natural gas from bank to bank without a compressor station since 2003. If there is a pressure differential, and this was testified to by the petitioner's witness, Dr. Sahu, it is the I-8 system and its interface with the I-9 system where the applicant must evaluate the potential need to overcome a pressure differential. But that interface between the I-8 system and the I-9 system is not part of this infrastructure crossing facility. It's not on either side of the banks that the hub line connects to and is irrelevant for this proceeding. Again, the hub line's been functioning perfectly fine since 2003 with no ancillary facility required. The reason why the applicant is choosing to propose the siting of the compressor station on the north parcel of 55 and 50 Bridge Street in Weymouth is because without the previously licensed infrastructure crossing facility that the hub line is, they cannot escape a full Chapter 91 waterways regulation and review, including whether or not the compressor station serves a proper public purpose. Now, the department has twisted itself into pretzels trying to justify overturning Presiding Officer Rothschild's far more reasoned, far more articulated, and far more detailed recommended remand decision on this specific question. This is not a situation where the question wasn't presented to Presiding Officer Rothschild, and therefore we're engaging in a remand proceeding. Make no mistake, this is the department's complete reversal of what Presiding Officer Rothschild did, and it's not because there was not evidence of environmental impacts in the record before Presiding Officer Rothschild. There were replete references of environmental impacts in Resource Report 10. Now, of course, there was new information submitted to the department, but when the department completed its review in this remand proceeding, it was obligated to review the 954 pages of trial testimony that were before presiding officer Rothschild to understand why she reached the conclusion that she did, so the department could be best informed in reaching a new determination that is subject of this proceeding. Now, the applicant's closing brief spends a lot of time and energy refuting the petitioner's position that natural gas has been flowing from south to north through the hub line without the assistance of a compressor station, and characterizes the petitioner's representations as grossly misrepresenting Mr. Bocock's 2018 testimony and plainly mischaracterizing Dr. Sahu's 2023 testimony. This is at page 16 of the applicant's closing brief. There's a long quotation of Mr. Bocock's testimony on August 1st of 2018. And if it's helpful, Mr. Chief Presiding Officer, I have some excerpts from that testimony that I can share my screen so that people can read along. If that's not necessary, I can just read the quotes.
I would read the quote.
Okay. So on page 16 of the applicant's closing brief, there's an extended quote of Mr. Bocock's testimony on August 1st, 2018, in which the argument is suggested that Mr. Bocock did not actually say that the Algonquin pipeline, and specifically the hub line, was bidirectional and gas has been flowing from south to north. And the question that's quoted on page 16 of the applicant's closing brief is read to Mr. Bocock, but does gas flow from the I-10 north to the Maritimes pipeline? And Mr. Bocock answered, it has. And he was asked, it has, how much? His answer was, I'd have to look that up, but yes, it definitely has. I know it has. And he was asked, well, give me an average. And he answered, it has flowed, well, 100 million, 50 million, 10 million cubic feet. I mean, the number varies all over the place. Now, the applicant argues that Mr. Bocock was referring only to shipments that were received from the Salem lateral pipeline, and that quote is taken out of context. Again, that's at page 107 and 108 of Mr. Bocock's testimony. But at page 111, so just a few pages after that, and this is in the administrative record at page 2677. But again, page 111 of the August 1, 2018 hearing testimony from Mr. Bocock. He was asked, so the Atlantic Bridge project essentially changes that purpose, is that correct? And Mr. Bocock answered, the reverse flow on the I-10 had already been achieved in 2007 through a separate file in Northeast Gateway, so it was already northbound flow available. The I-9 was already authorized to go, towards the I-10, and in the I-10 authorization, the I-9 project and the hub line project were both in together. So the I-9 could flow in either direction. So if you wanted to boil it down, the I-10 already flowed north. That's Mr. Bocock's testimony. It's not limited to the Salem lateral pipeline. It is the I-9 flowing north. It is the I-10 flowing north. And this has been achieved since 2007. In Mr. Bocock's pre-filed testimony, this is cited in the applicant's closing brief at footnote 4 and footnote 5. It's Mr. Bocock's supplemental pre-filed testimony dated July 25th, 2018. It's at the administrative record from pages 2293 to 2296. At page 2296, and this is pre-filed testimony, so this wasn't cross-examination. This is what the applicant submitted. Mr. Bocock was asked, could natural gas flow from the I-9 into the I-10 without increasing the pressure? And his answer was yes. Algonquin could operate the I-10 at a lower pressure. And again, that's without the compressor station. Mr. Bocock's pre-filed testimony at Administrative Record 2293, again, this is cited in the applicant's closing brief. He's asked, how did Algonquin determine it needed additional pressure on the I-10 in order to achieve the AB project purpose, so the Atlantic Bridge project purpose? His answer, Algonquin conducted a hydraulic modeling analysis of its existing pipeline system, including the I-8, I-9, and I-10 segments, to determine whether the system could operate using only its current facilities. And then further down, he states, while the MAOP, so the maximum operating pressure of the I-9 and the I-10 are similar, again, there is no pressure differential between the I-9 and the I-10. He states, while the MAOP of the I-9 and the I-10 are similar, the actual operating pressure in the I-9 for natural gas flowing north is limited by the actual operating pressure of the I-8. So this problem that the applicant is trying to solve has nothing to do with the hub line. It has nothing to do with the previously licensed infrastructure crossing facility that crosses from bank to bank. They've got a problem somewhere else on their system, but they can't put a compressor station somewhere else on their system because they don't have a previously licensed infrastructure crossing facility to try to attach it to. They're trying to escape the regulatory review that should be required of every natural gas compressor station proposed for construction in jurisdictional tidelands. And this has been known since Resource Report 10, which on page 10-33 in section 10.8.3 lists the I-8 and I-9 systems evaluation. At Resource Report 10, section 10.8.3, it lists the I-8 pipeline system has a lower MAOP, maximum operating pressure, of 958 PSIG than the I-10 system pipeline, which is 1440 PSIG. The I-9 system has an MAOP potential of 1250 PSIG. And Resource Report 10 says the I-9 system's MAOP can be increased to 1250 PSIG, which is exactly why Mr. Bocock submitted pre-filed testimony stating the MAOP of the I-9 and the I-10 are similar. Now, the definition handed down by the Norfolk Superior Court includes an important phrase that Presiding Officer Rothschild did focus on, that has again been omitted by the department and has been omitted by Algonquin in this proceeding. Everyone is focused on the required, demanded, or made necessary because it is suitable or appropriate language. And the petitioners agree that is an important part of this proceeding. But a full reading of the Norfolk Superior Court's order states that the department omitted the preceding language to call for as, and that's quoted. And this was and that begins at the end of page 6 and continues on to page 7 of the Norfolk Superior Court order.
But excuse me, Mr. Hayden, on page 7, the court said the quote unquote to call for language omitted by the department means of a thing to require, demand, to make necessary. And the court cited the Oxford English Dictionary. And then the court went on, accordingly, quote unquote, to call for suitable or appropriate means something is required, demanded, or made necessary because it is suitable or appropriate, not that it's simply suitable or appropriate. Isn't that what's the court said?
It is, and that's what Presiding Officer Rothschild analyzed. She's criticized by the applicant because she actually used the to call for language in her analysis, which is exactly what the Norfolk Superior Court required everyone to do.
So are you saying to me that it's unreasonable for the department in making its determination on whether or not a facility is an ancillary structure to a crossing facility, infrastructure crossing facility, that environmental consequences don't fall in the realm or calculus of what to call for means, or don't fall into the calculus of what required, demanded, or necessary mean? I don't know if I follow that.
No, and thank you for the question, because that is absolutely not the petitioner's argument. The petitioner's argument is there's been a lot of question as to whether the regulation imposes a review standard that requires the department, and it's, I apologize, I'm looking for words to describe this, Mr. Girolandino, without using the word requires, because when I argue with requires and the definition includes requires, it becomes confusing. But the department has stressed that an adjacent location has nothing to do with operationally related. That's the hill that they have chosen to stand on. And the petitioners completely disagree, because reading the Norfolk Superior Court's decision of to call for as, you cannot require an adjacent location unless the infrastructure crossing facility calls for the ancillary facility. That is consistent with every single example that's set forth in 310 CMR 9.02, whether it's sewage headworks or drainage. In every single instance, the infrastructure crossing facility that's running from bank to bank, if it's a ramp to a bridge, calls for the ancillary facility in order for the infrastructure crossing facility to function. Here, the hub line is not calling for the compressor station to function. It's Algonquin's customers in Maine and Canada that are calling for the compressor station in order for the Algonquin gas transmission pipeline to function well outside of Massachusetts. So here what we have, to answer your question, Mr. Girolandino, it's absolutely essential that the department consider environmental impacts of a proposed ancillary facility, because what the applicant is proposing, what the department has agreed to, is that in order to facilitate shipments to Maine and Canada, we can drop a natural gas compressor station in our jurisdictional tidelands here in Massachusetts. There's no discernible benefit to our Massachusetts residents. And this has been the subject of other proceedings. The gas is not being shipped or pushed through the compressor station for local distribution. This is going to Canada. It's going to Maine. And the Massachusetts residents, and I'm glad that Presiding Officer Gruhl noted the public trust doctrine and the Commonwealth as a fiduciary to protect jurisdictional tidelands, because all that's being done here is the desecration of jurisdictional tidelands for the benefit of people who don't reside in Massachusetts. So I agree completely. The department should make a very focused review of environmental burdens and impacts, which I'm very happy to comment if there's time to do so on the environmental justice regulation and argument that has come down, because I think that all works together. I know that the applicant has argued that there's a section 102B in the 2021 Climate Act that limits application of the new environmental justice law to only new projects. But the applicant makes the argument for me or for the petitioners, because section 102B states that new projects is limited to 62A projects that require an environmental notification form. And here the applicant agrees, and so do the petitioners, that this is not a 62A project. There was no environmental notification form submitted, and 102B's limitation to new projects applies only to 62A projects. Everything else falls within the much broader sections 58 and 59, which state that an environmental impact report shall be required for any project. and that no agency shall exempt from an environmental impact review report any project that is located in a neighborhood that has an environmental justice population and is reasonably likely to
Mr.
cause
Hayden,
damage to the environment.
Excuse me, Mr. Hayden. I don't mean to interrupt you, but I think we're going off on what I was looking for. But since you brought up environmental justice, there was no testimony provided by Dr. Sahu on environmental justice. The only testimony was about his opinion regarding whether or not the department's determination on remand was correct or not. And so isn't the lack of, assuming that EJ is part of the review process here, because the Superior Court made it clear it was only for one issue and one issue only, and that was regarding the definition of the word requires as the court ordered it. It did not require another EJ review. Ms. Hops, nevertheless, if I remember correctly, presented testimony in her pre-filed testimony, whether it was direct or rebuttal, commenting or pointing out that the department did conduct an EJ review. But I don't see any counter testimony from Dr. Sahu that what Ms. Hops testified was without merit or was inappropriate. And so assuming that you can make an EJ argument here based on what the Superior Court ordered, isn't it fatal to your EJ claim because you didn't present any expert testimony on the EJ? It's basically legal argument. I mean, and what I'm trying to get at, as the record stands, you have Christine or Ms. Hops' testimony, excuse me, of pointing out that there was an EJ analysis performed, and there's no counter testimony from the petitioners. It's just argument. And so I will take under advisement what you have indicated in the closing brief of where the petitioners believe that an EJ analysis along the terms that you argued in the closing brief has to be part of the review here. But I want to get back to what I had asked at the very beginning with Mr. Bragg, and then Mr. Cram followed up, and that is the department. So are you saying, representing at this point, because I'm trying to get to be to have an understanding here of what the petitioner's position is on this regulation on 310 CMR 90.2. So is it the petitioner's position at this juncture that the calculus of determining, or excuse me, the determination of whether or not a structure requires an adjacent location, whether or not, in other words, it's an ancillary facility to an infrastructure crossing facility, that termination can include potential environmental impacts of other possible locations of the proposed facility? Is that the petitioner, that's a reasonable construction of the regulation by DEP?
It is. There should always be consideration of environmental impacts, but what is not reasonable and what the petitioners oppose is the department's deference to the applicant's description of need for a project purpose that extends into Maine and Canada. The sole focus of the department should be the hub line from bank to bank, which is all an infrastructure crossing facility is. That hub line by the applicant's own testimony is bidirectional and has flowed gas from south to north since 2007. And that's the added testimony that is still part of the record that I read during my argument today.
Yeah.
So
yeah,
whether
yeah. Go ahead, I'm sorry.
That's okay. The question that Presiding Officer Rothschild asked about deference to FERC's decision in EFSBs, I think is exceedingly relevant because the applicant submitted these 7 proposed alternate locations to FERC, and represented to FERC that they were technically feasible, that they could be completed within an acceptable cost. And they were submitted for FERC's review of an environmental assessment. And the irony here is that despite having submitted alternatives that were technically feasible and reasonable in cost, and having been submitted to an environmental and assessment review conducted by FERC, the applicant's position to the department is that all of those alternatives were never going to be environmentally acceptable to the Commonwealth. There's an inherent disconnect in the representations that the applicant is made to FERC and that the applicant is made to the department. And if that was the case, for the department to complete an appropriate review of whether the previously licensed infrastructure crossing facility requires this compressor station, it should be limited to acceptable environmental alternatives, not limited to what was submitted to FERC in connection with the environmental assessment.
But I'm going to go back again to my original question to Mr. Bragg, and as discussed also by Mr. Cram, that you are contending at this juncture on behalf of the petitioners that environmental impacts of alternative locations can be, it's reasonable for the department to include it in the calculus of determining whether a proposed structure requires an adjacent location to an infrastructure crossing facility. In other words, as that is an ancillary facility. And I'm asking you again, because I'm looking at paragraph 30 of Dr. Sahu's testimony. And if for counsel, if you have it handy, I urge you to pull it out, where I think your position is contrary to what your own expert testified to at trial. And I just want to get a sense of what is the petitioner's position on the environmental consequences of potential alternatives. That there may, I'm reading in paragraph 30, that there may be claimed environmental benefits or cost advantages to locating the station as proposed are not factors that are relevant to the engineering need or requirement that it be made located to the hub line for it to be functional.
So I appreciate the question, and I'll try my best to address it. And this, what Dr. Sahu and the petitioner's expert is expressing is what I've tried to communicate. The hub line as an infrastructure crossing facility, bank to bank, that's consistent with what Dr. Sahu is saying. What he's saying is not relevant is if you consider the entire Atlantic Bridge project needs. You can't call environmental impacts that are the result of shipping gas to Maine and Canada. You can't include that as a consideration for the department's review, because otherwise it would always be trumped by the no action alternative. The applicant's own witness said that with no action at all, there is no environmental damage. And so the best outcome for the residents of the Commonwealth of Massachusetts, which the department under the public trust doctrine has a fiduciary duty to protect, the best outcome for the residents of Massachusetts is a no action outcome. And the only thing that can push the department off of a no action outcome conclusion is if the applicant demonstrates that the infrastructure crossing facility from bank to bank requires an ancillary facility in an adjacent location in order to function. Sewage head works, drainage, on-ramps, off-ramps, all of that focuses solely from bank to bank. Here, the applicant's focus has never, ever been from bank to bank. It's only been, can they get gas to Maine and Canada? And the applicant's testimony throughout these proceedings have concluded and confirmed that the hub line can function in both directions. It's flowed gas from south to north since 2007. The pressure differential that exists is not at the I-9, I-10 interchange. It's further back down the pipeline. It's at I-8, I-9. And so this environmental damage question that you continue to ask about, and I'm trying my best to answer it, it's relevant for the department to consider, but only in the context of what the infrastructure crossing facility needs.
But I don't think the regulation says that. I think you're reading in, I'm being a devil's advocate here. I think you are reading in provisions in the regulation that the residents would like to have there. And I'm going back to Dr. Sahu's testimony. The more I read on, the more I believe that the residents have taken a contradictory position here, whether or not the department, with respect to 310 CMR 902, in determining whether or not a proposed structure is an ancillary facility to an infrastructure crossing facility, can take into account environmental consequences. With respect to the environmental, these are his words. These are in effect, quote unquote, nice to have as opposed to must have factors. While it may be beneficial to minimize environmental impacts, and it is doubtless beneficial to the operator to minimize cost, these virtues do not make it necessary what the Weymouth compressor station be located adjacent to the hub line or the I-9 for that matter. Seriously? That is what Dr. Sahu said? I mean, I read it originally, but seriously? It's a nice to have as opposed to must have factors? I don't know about that, Mr. Hayden, but finish with your argument. Please, continue. I'm just going by what your own expert said. That's all. Paragraph 30.
I understand, and I apologize to the extent that my engineering expert was inartful with his language. My representation to you is that the distinction he was drawing in his mind is whether the hub line can function as is, and whether it's relevant to consider these environmental impacts in order to facilitate moving gas to Maine and Canada. And his clear conclusion was that the hub line does not need compression. He said that over and over and over. And so what he was describing is not relevant, is whether the applicant will do more damage to the environment by adding a compressor station to get gas to Maine and Canada. I think if you asked Dr. Sahu the question of, is it relevant to determine environmental impact if your sole focus is limited from the operation of the hub line from bank to bank, he would say yes.
I have a question. I want to kind of jump in here because I'm trying to understand how this works in practice for the department. You know, in this instance, it seems to me that you're still asking whether this facility, that the department should be asking whether this facility is necessary or not in the context of this project. Am I understanding that correctly?
Absolutely. So I think, right. Presiding Officer Gruhl, that question has to be asked in order to satisfy the inquiry and evaluation of whether the compressor station, the hub line, requires the compressor station to have an adjacent location.
Here's the difficulty that I'm having is I'm struggling to see how this is workable in practice. So, you know, as we're sitting here today, we have the benefit of an adversarial system where both sides have put in engineering experts who, you know, who deal with these kinds of gas lines for a living. If the department is assessing a Chapter 91 application, you know, on its own, it's not necessarily going to have the benefit of those folks, and it would hardly be efficient for all applications to end up here. You know, so the example that comes to mind is, you know, in the definition, there's a toll booth listed. Are we going to require the department to hire economists to determine whether a toll booth is going to be, you know, it's going to maximize revenue, you know, in one location as another and counterbalance that against the environmental effects? I'm just having trouble seeing how this works on the ground in practice outside of this case.
So that's a great question, and I'm glad you asked it because that really hits on the petitioner's argument. The toll booth has to be there right at the bridge because that's how the owner of the bridge or whoever's maintaining the bridge is tracking the use of the bridge, right? The car enters the toll, pays the fee, whether it's Easy Pass or quarters in the drop boxes in days past. But it's all related to that bank-to-bank infrastructure crossing facility. The applicant that's requesting a toll booth for a bridge is not concerned about whether that car that crosses the bridge drives to Maine or Canada. Everything is focused at the local level on the bank to bank. That's the same with ramps, interchanges, ventilation shafts. Everything is facilitating that infrastructure crossing facility. And I think that's a pretty straightforward description in the application, and one that doesn't necessarily take a whole lot of time for the department to complete its review. I think the 10 examples that are listed in section 310 CMR 9.02 are perfect instances of how this operation should work and how seamless and expedited the department's review can be when the necessity of the infrastructure crossing facility to function because of the ancillary facility adjacent location is just blatantly obvious. Here, it's not blatantly obvious. It's not obvious it shouldn't be obvious to the department why a pipeline that's been functioning since 2003 all of a sudden needs a brand new natural gas compressor station and jurisdictional tide line. The explanation that's been offered the department is there's a pressure differential right at the interface between the I-9 and the I-10 where the hub line begins, but that's not true. The pressure differential is further back on the pipeline. It's between the I-8 and the I-9, and in order to overcome that pressure differential, the applicant has a number of different solutions, and they've accomplished that because they've been flowing gas through the hub line, both south to north and north to south, both directions since 2007. So the explanation that the applicant has given the department in terms of why this proposed ancillary facility requires an adjacent location, it's all fabricated. It's all presented in order to take advantage of the previously licensed infrastructure crossing facility status, which is critical to the applicant because that grandfathers in the water dependent classification of the hub line. Absent an ancillary facility conclusion, the compressor station is not water dependent and therefore is subject to the department's many other review processes. And the petitioners would submit that the applicant can't satisfy a non-water dependent review for the compressor station. But I appreciate your question, Presiding Officer Gruhl, in terms of, do we make this more complicated than it needs to be by following the petitioner's argument? And the petitioner's position is no, because this is such a unicorn. This is the only compressor station in jurisdictional tidelands in Massachusetts. It's the only compressor station in jurisdictional tidelands for the entire Atlantic Bridge project. There's nothing that is going to be problematic in terms of precedent by favoring the petitioner's argument in this proceeding.
We're approaching 12 noon and almost 2 hours of the oral argument. Presiding Officer Rothschild, do you have any questions for Mr. Cram? Excuse me, Mr. Hayden, I apologize. You're on mute, okay.
I do not. The only point I want to make is I believe that it had been established that the bottleneck exists between the I-9 and the I-10. There was substantial testimony during the prior iteration of this from Mr. Bocock, and I think confirmed by others, that the pressure differential and the bottleneck existed between the I-9 and the I-10, and that was why compression, whether it was at the cited location or elsewhere, needed to exist. That's where the bottleneck is. That was the obstacle that needed to be overcome. And I don't see in the record in this remand proceeding that that's really in dispute.
Presiding Officer Rothschild, refresh my memory, because you handled the air permit appeals with respect to the compressor station.
I don't really remember, but I think so.
Unless I'm incorrect, I believe a lot of what has been stated here about the pressure of all this stuff, I think was litigated in the air permit appeals. And because I observed, I heard those hearings. And so I'll go back to it, but it seems that we are re-arguing air permit issues. I mean, I don't know if you agree. I don't know.
I don't agree on that point. Okay. That the real issue that was in this case is the need for the compression to get gas flowing north through the I-10 from the I-9, because the MAIOPs are different, lower in the I-9, higher in the I-10. So the I-10 can be bidirectional, but you can't get what Algonquin established is that the gas can't get into the I-10 from the I-9 because of the pressure differential. So compression in some location was needed to overcome that bottleneck.
Can I speak to
Thank
that
you
very-
for, well, let me finish. Thank you for clarifying that for me, because I honestly, the air permit appeals were a while ago. And so, thank you. Mr. Cram, you wanted to say something?
Just that presiding officer Rothschild is exactly right on this question, and there really is no dispute in the record. Gas cannot move without the compressor station from the I-9 into the I-10 in a sufficient quantity to satisfy the purposes of the Atlantic Bridge project and Algonquin's contracts. The reason is because there is an operating pressure differential between the I-9 and the I-10. The testimony, if you'd like to refer to it, is exerted at page 14 of our closing brief from witness Bob Bocock, who presiding officer Rothschild just referred to, who speaks directly to this. The analysis, he actually performed a hydraulic analysis, showed that the system's current facilities cannot transport natural gas from the I-9 into the I-10 because the operating pressure, not the maximum pressure of the pipelines, in the I-9 is lower than the operating pressure in the I-10. The notion that Mr. Hayden has focused on the physical possibility that molecules of gas could move if you turn down the pressure in the hub line from the I-9 to the I-10 is totally irrelevant, because if you turn down the pressure of the I-10, then you cannot move gas in a sufficient quantity to satisfy Algonquin's contractual obligations and the purposes of the Atlantic Bridge project. From a fundamental perspective here, there's a real problem with what Mr. Hayden has argued, because he's done something here that his own expert was unable to do and did not add to the record. His expert admitted Dr. Sahu did not perform a hydraulic analysis of the pressures in Algonquin systems and anything about the need for this compressor station. He did not do a scientific or technical analysis of those points. And Mr. Hayden can't stand up now and do that for him. We also heard that there's no discernible benefit to Massachusetts from this project, which is absolutely a false statement. One of Algonquin's customers is the power plant in Salem. It's where some of the gas goes. They have a contractual obligation to supply gas there. The notion that there's no benefit to Massachusetts is wholly false. Just very quickly on the examples from the regulations that you heard Mr. Hayden cite, toll booth and power transmission substation, they're actually directly analogous to what we're talking about here. You put a toll booth at the entrance to a bridge to collect the toll because that's where it makes sense to put it. Just like the compressor station, you could go through tortured means to pull a toll booth back from a bridge and away from tidelands, where a bridge is an infrastructure crossing facility, by using completely unnecessary and burdensome road or connectors or something to take it off of tide lines and off of the shore. You'd never do that because it doesn't make any sense. In the same respect here, you'd never move the compressor station away from the hub line here, because doing so would be so impactful to the environment and other tidelands. The same thing is true with respect to a substation. Power transmission substations, and this is demonstrated in the East Eagle substation case, which is cited in the department's brief, and in the Ohio case that's cited in our brief. Just like a compressor station, a substation can be pulled away from an infrastructure crossing facility by the development and construction of complicated high power transmission lines, which would be completely unnecessary if you located the substation next to an infrastructure crossing facility. Same thing.
Anything else you wanted to add?
No, thank you.
Mr. Bragg, anything you wanted to add for the department as we wrap up?
Sure. Just to go back, and I know you explained this at the very beginning. I think the petitioners are still conflating the application of the word required and sort of misapprehending it. It doesn't apply to the relationship between the infrastructure crossing facility and the ancillary facility. The standard there is operationally related. The word required appears later in the definition after the word and, requires an adjacent location. So the required element, the need element, the necessity element, all discussed from the Superior Court remand, that applies to the location. This great deal of electronic ink expended in talking about how the hub line could operate without the compressor station isn't really related. Even Dr. Sahu admitted, as constructed, the compressor station is operationally related to the hub line. And I would also echo Mr. Cram in looking at East Eagle. All of the examples cited, power transmission substations, they could all be located elsewhere. East Eagle was originally determined or originally planned to be located elsewhere. The whole fight in East Eagle was locating it elsewhere. So the petitioner spent so much time talking about how all of those others are distinguishable because they absolutely must be next to the parent facility. It's not distinguishable. The same challenges would apply. It would be with some effort you could relocate it, but it's certainly not impossible. And again, to go back to the EFSB's, I think EFSB's well-reasoned final decision, if we were to apply the standard of can it theoretically be located elsewhere, then you don't qualify. That would just preclude any facility from qualifying as an ancillary facility, and it would render the regulation meaningless.
Well, thank you, everyone.
So could I ask?
I'm sorry.
No, I appreciate it. I had actually two more questions very quickly.
By all means.
The first, for Mr. Hayden, the first I asked the others, so I wanted to make sure that I asked you as well. What do you see as the scope of review in this matter? Is it any greater than the definition of the word requires and its application in this instance?
So thank you, Presiding Officer Gruhl. I think it's the entire consideration of the compressor station as an ancillary facility, which would include being at least cognizant of the operationally related piece, and then certainly the Norfolk Superior Court's definition of the word requires as it applies to the requires an adjacent location from 310 CMR 9.02. But for the passage and enactment of the Climate Act, I would agree that that is the sole scope of this remand proceeding. But the Climate Act has been enacted and has been in effect since June of 2021. And as a result, the application of the Climate Act and the requirement for an environmental impact report to any agency review is unmistakable. And I understand that there's an argument that this proceeding was initiated in 2015 and therefore the Climate Act does not apply, but that's not what the Climate Act says. In Section 102B, the limitation to new projects is only applicable to 62A projects that require an environmental notification form. That's not what we have here. So the moment this case was remanded back to the department, Ms. Hops confirmed that the Environmental Policy Act applies to the department. So it's just a simple question of whose responsibility is it to complete an environmental impact report. And I agree with the department's position in its closing brief that it's the applicant's obligation to complete the environmental impact report, not the department. And Section 58 of the new law states that the secretary may require that an assessment be performed at any stage of the review process. So here we're clearly within that any stage language. So the scope of this review, and to Chief Presiding Officer Girolindino's point, the petitioner's position on environmental justice is that no witness is required because this is a regulatory requirement. Chapter 8 session of the Act, Chapter 8 Act, Section 102 requires the department, with or without the petitioner's requests. Clearly, from the very beginning of these proceedings, the petitioners have requested environmental justice review. There was some outreach done 7 years ago with translations made to other language, but that is not sufficient with regard to the new law, the 2021 Climate Act. There's more required and has been required of this and every other agency since June of 2021. And the outreach that was performed in 2017 doesn't satisfy the department's obligations under the 2021 Climate Act. And at the very least, the petitioners respectfully request that the determination of an ancillary facility classification be rejected. But even if it's not, the petitioners also request that this Office of Appeal and Dispute Resolution remand this entire application and project back to the department to complete the environmental justice review that's required under the 2021 Climate Act.
So in your Superior Court case, and looking at the docket, the 9A package for your 12C motion that was filed November 16th, 2020, and the hearing wasn't even scheduled until February 3rd, 2022. In your pleading, either when you filed it at the beginning, since you said you'd been discussing this issue since, from the beginning, or after you filed that 9A package, did you ever amend your complaint to add this environmental justice issue?
Before the Norfolk Superior Court?
Yes.
I certainly would have, but on Chapter 30A, Section 14 review, we were limited to the administrative record that existed before Presiding Officer Rothschild. I think it was in 2018. So we've raised environmental justice before the Mass DEP in every proceeding, including the air permit, including the waterways, and until the 2021 Climate Act went into effect in June of 2021, it was always discretionary, and the department never exercised its discretion to do more than the public outreach that was performed 7 years ago. And that's what went up to appeal in the First Circuit. The First Circuit said the department was within its discretion not to do more. But now, for the first time, the department is no longer within its discretion to not insist upon an environmental impact report. And that's what's changed since we took the appeal to the Norfolk Superior Court. We were limited to the administrative record that was compiled in 2018. And on remand now, it's the petitioner's argument that the scope of the 2021 Climate Act is absolutely applicable to this proceeding.
Well, Mr. Hayden, if I'm following up on something you said, that even if Mr. G.R. Landino agrees with the department that this is an ancillary facility, do you believe that OADR and the chief presiding officer has the discretion nonetheless to remand to the department for further EJ analysis? Is that what you're asking?
That is what the petitioners are asking, because that EJ analysis has never been completed. And if that EJ analysis, there is a whole host of requirements that are imposed upon the department. If the results of the EJ analysis come out a certain way, for example, there's an assessment of any existing unfair or inequitable environmental burden and related public health consequences. And if that's the case, then it triggers further review. And here, when the department is considering the totality of the applicant's submission, which includes whether or not the compressor station alternative sites are technically feasible, cost acceptable, cause environmental damage, it is incumbent upon the department to also include the results of the environmental impact report requirements under the 2021 Climate Act. So even if, based on this record, Chief Presiding Officer G.R. Landino agrees with the department on the question of ancillary facility, upon remand, the department would be within its rights to consider the environmental impact report and all of its review obligations under the 2021 Climate Act, and then determine that there's an undue burden on this environmental justice population. There are 4 separate communities living in Quincy, Braintree, and Weymouth that have lived in this area and historically have been overburdened. And that's an issue that the petitioners have with the department's rationale. This is the playbook for prejudice against environmental justice communities. The department has just blatantly said, we're going to cause more damage to the other non-EJ communities. So we have to approve the siting of this facility here. This is what the 2021 Climate Act was designed, if not to prevent, at least to require additional review so that there is a reasoned decision that's presented in terms of why environmental justice communities in the future will continue to be subjected to such harmful projects.
And I want to follow up because I remember when this came back from the Superior Court and I conducted, I think it was a status conference with the parties. And I asked department counsel, who at the time I think was Mr. Fallon, if the Climate Act didn't require the environmental justice review, did the department nonetheless have discretion to engage in that? And he acknowledged that it did. So what you're asking for is the department to exercise its discretion, what you see as its discretion afforded by the Climate Act, to conduct an environmental review, notwithstanding a decision upholding the department's determination in this matter, if that is what Chief Presiding Giorlandino does.
Well, Presiding Officer Rothschild, I appreciate the question because I've answered that differently in the past. And I remember your presiding over that conference, and you specifically asked me a question about Section 102B in the Climate Act and whether the requirements to complete an environmental impact report were limited to new projects. And I'll admit today that I was less prepared to answer that question. And honestly, it took reading the briefs over and over in preparation for this proceeding for a light to finally dawn over Marblehead in terms of how I'm prepared to respond to your question today. Section 102B, the limitation to the applicability of the 2021 Climate Act to new projects, is by its own language limited to Section 62A projects, which require an environmental notification form. That's MEPA threshold review. And that's not what we have here. The applicant admits this is not a 62A project. There was no environmental notification form. This did not trigger MEPA thresholds or MEPA review. So that takes us outside of Section 102B. There is no longer a limitation to new projects, so it's no longer discretionary. Now we're within Section 57 and 58 and 59, which say that every project, any project that is likely to cause damage to the environment and is within 1 mile of an environmental justice population shall require an environmental impact report. I no longer, today, I'm answering your question differently than I did 2 years ago. I no longer see this as discretionary. It is discretionary for 62A projects. It's not discretionary for non-62A projects.
Anything else, Presiding Officer Rothschild?
No, I would, question if either Mr. Bragg or Mr. Cram has a response to that.
Well, I was going to do that. You and I are on the same page. Why don't we start with Mr. Cram, and then we're going to end it with Mr. Bragg. Okay? Mr. Cram.
It's really not clear to the applicant exactly what the residents group is asking the department to do here. What is clear is that the Climate Act in Section 102 specifies that the environmental impact report requirement applies only to new projects that are filed under Chapter 62A of Chapter 30 of the General Laws. And this is not a new project, as the applicant originally applied for the license in 2015. And FERC issued its notice to proceed with construction in 2019, and the compressor station was placed into service in 2021, all before the Climate Act was enacted and became effective. We also heard today from the petitioners that they agree that this is not a MEPA project. It doesn't trigger the MEPA thresholds. So neither of the provisions that would make Section 58 of the Climate Act apply are triggered here. It doesn't apply. Section 59, which Mr. Hayden also referred to, applies when there's a facility in a neighborhood that has an environmental justice population. And there's no dispute in the record that the compressor station is not in a neighborhood as that's defined with an environmental justice population. And then he referred to the language that would allow the secretary to require the preparation of an environmental impact report. And the secretary, of course, is the secretary of the Office of Energy and Environment, and not the presiding officer in this proceeding. And so what he seems to be asking the department to do is to step in and play the role of the MEPA office and to require something that doesn't otherwise apply in the regulations. And I don't think that's the right thing to do here. And I think it is important to remember both that there was really substantial public participation provided with respect to the Chapter 91 license specifically. There was a public hearing. There were translators provided at that hearing in Spanish and 2 Chinese dialects. There was free transportation provided from Quincy. There were over 250 or around 250 public comments received and responded to by the department, where this all comes relevant and demonstrating that that process worked is that thereafter, when the governor's office commissioned Mass DEP and Mass DPH to conduct a health impact assessment, which was completed in 2019. One of the things that they found there was that this whole process resulted in the creation of a formation of community groups, public official and statewide groups. There was independent air and noise monitoring done. And obviously, as a result of all of that, the enhanced public outreach had a meaningful effect. One of the flaws in the residents' argument here is that they want the department to have done something more without saying what that more is. And the First Circuit has already looked at that exact same argument and rejected it on 2 different occasions when it was examining the proceedings relating to the air permit. The exact same argument was made in those cases, and the First Circuit rejected in both cases. And then finally, I just want to add here too that it's important also to remember that the department has testified in this proceeding that it did fully consider this project with respect to Chapter 91 and its regulations in the context of the new environmental justice policy, the 2021 policy, in this proceeding. And it found it to be consistent with the environmental justice principles therein, that the process has provided meaningful involvement and it did not result in environmental benefits or burdens with respect to Chapter 91 interests. And the reason that the department could make that finding is that the compressor station does not interfere at its current locations with the public's ability to access tidelands and waterways. It has it's set back from Kings Cove by the Kings Cove Conservation Area, which remains open and which Algonquin has agreed to provide both pedestrian and vehicular access and parking to. And it completely separates the compressor station from the waterfront. So there's no impact on the public's ability to fish, fowl, or do any of the things that they can enjoy with respect to the water. No impact at all.
Anything else, Mr. Cram?
No, thank you.
Mr. Bragg, yours to conclude.
Thank you, Mr. Alandino. I just want to follow up on that last piece that Mr. Cram mentioned, and it was going to be the first thing I talked about. Not only are we bound by the scope of the remand here, but in raising the issues that Mr. Hayden wants us to look at, we're also bound by the scope of Chapter 91. So when we're looking at environmental justice, we're looking at potential damage to the environment. We're looking at it through the lens of Chapter 91 interest. And this project has been found over and over not likely to cause damage to the environment. And that's a piece of the 2021 Roadmap Act that Mr. Hayden has elided a couple of times. When he talks about this shall have an EIR, it's for projects likely to cause damage to the environment. That does not apply here, certainly not within the context of Chapter 91, where, as Mr. Cram noted, this is located away from tidelands and the public has full access to the tidelands in that area. So it's not interfering with those traditional values. And in fact, I think the only way that this could run afoul of environmental justice principles within the scope of Chapter 91 would be if it were the compressor station were relocated to another area, because it would unavoidably, as Mr. Cram pointed out, not just impact some far off area through acres and acres of jurisdictional tidelands, but including the Kings Cove area. The pipes would have to go back to that point anyway. So you'd be putting this additional burden on the very community that Mr. Hayden claims to be trying to protect and work in the interest of. So you would increase the burden to them, you would increase the burden elsewhere, and you would be causing completely unnecessary environmental damage and adverse impacts to resource areas and Commonwealth tidelands. So I think that just reinforces the current location, which didn't disturb an extra square foot off-site of jurisdictional tidelands, is the best location for this, and it easily falls within the scope of a ancillary facility.
Thank you, Mr. Bragg. Now, before I conclude, I won't repeat the mistake I made earlier. Presiding Officer Grew, any other questions for Mr. Bragg?
No.
Presiding Officer Rothschild, any other questions for Mr. Bragg?
I have no further questions.
Okay. Thank you, everyone. I am concluding the closing arguments of counsel in this matter. I've taken everything under advisement. I don't believe any further briefing is necessary. The issues have been thoroughly briefed by all sides. And as I indicated earlier, any decision I make is a recommended final decision on remand. The ultimate decision maker is the Commissioner of DEP, who, as I indicated earlier, takes her role as the final decision maker in administrative appeals very seriously, and will have the benefit of not only my recommended final decision on remand, but the administrative record and the recording of this oral argument, so she can hear for herself what counsel argued today. So thank you very much. For those who watched the oral argument of counsel, thank you for doing